Morning, everybody. Thank you for joining us. I'm Catriona Attride, and I'm joined today by my colleague Grace Endley. We recently held this session as an in-person seminar, and it proved to be extremely popular, hence why we're here today, reaching a slightly wider audience. Normal expenditure out of income gifting has had an important place in estate planning for a long time, but it does seem to be coming to the forefront of minds following the autumn budget, as we look to maximise the use of thresholds and allowances that have survived the Chancellor's squeeze. There's not that many being left with us. By the end of this session, you should have an understanding of the difference between making gifts from capital versus making gifts from income. We'll cover how we calculate surplus income and the importance of record keeping. We'll have considered the requirements to qualify for the relief. And we'll have a look at the different ways surplus income can be gifted and how this fits in with overall estate planning. When we make a gift to an individual or a trust, there's a loss to the estate for IHT purposes. If that gift is made outright to a person, it might fall within the annual exemption of £3,000. Otherwise, it's going to eat into a person's nil rate band, which is £325,000. If you make outright gifts exceeding your nil rate band and die within 7 years, those gifts will become chargeable to IHT, subject to taper relief. If a gift is made to a trust of non-relievable assets, you're only able to gift £325,000 in a 7-year period without triggering an immediate charge to IHT. Now, this all might sound familiar, and I think we can all agree that these allowances aren't particularly generous, and they certainly show no signs of being increased. We've had the same nil rate band now since April 2009. What sometimes gets missed, though, is that there's a really valuable exemption in Section 21 of the Inheritance Tax Act, which allows unlimited gifts of a person's surplus income to be made without that gift eating into their nil rate band, and which they don't need to survive 7 years from making. The relief is often overlooked, almost forgotten, and whilst there are conditions to be met, with careful planning, IHT savings can be made. I'm going to hand over to Grace now so that she can have a look at what surplus income is and how we calculate it.
So Catriona has outlined what we mean by surplus income, and I'm now going to look at some of the detail. There are 3 conditions for the exemption to apply. Firstly, the gift must form part of your normal expenditure. Secondly, it must be funded out of income. And finally, you must be left with sufficient income to maintain your normal standard of living. So with regards to the first condition, normal expenditure means normal for the person making the gift and not the average person. In order to show a gift is normal, it must have some pattern to it. And showing there's a pattern is not what you might expect on the face of it, as a single gift can qualify if there's clear evidence of an intention to make regular gifts, which Catriona is going to come on to in more detail shortly. And equally, a number of gifts might not qualify if there's no pattern to them. There are a number of factors that need to be considered, which include frequency, amounts, nature of the gift, identity of the people receiving the gift, and reasons for the gift. Looking at frequency first, there isn't a set time span over which you must show a pattern of giving. Typically, HMRC will be a reasonable time span as 3 to 4 years, but that's not to say that there aren't exceptions. So gifts don't have to be regular or annual, but as mentioned, they must form a pattern, and gifts made on a regular basis are more likely to meet the test. So just to give you an example of gifts that may qualify for the exemption, if, say, you had 3 children and you were making gifts from income of £1,000 to each of them on their birthdays, along with £500 to each child at Christmas, those gifts would form a pattern and be exempt. Moving on to amounts, HMRC do look at the amounts of the gifts, and they suggest that gifts should be of comparable amounts. And if there are material differences in the amounts, they will expect an explanation. So, for example, if your source of income had materially changed one year, a gift that's materially larger than others will require an explanation. So for example, if you've been making those £1,000 per year birthday gifts, and one year you decided to make a £100,000 gift to the children, it could be seen to fall outside a pattern of giving, and relief could be denied entirely or in part. Now, that's not to say we haven't had cases where HMRC have accepted gifts that are materially larger than others, because we have. And in reality, each case needs to be considered based on the individual circumstances. Moving on to the nature of the gift, generally the gifts need to be as cash to fall within the exemption, and we're going to come on to that in more detail shortly when we look at what actually constitutes income. Identity of people receiving the gift. In terms of who the gifts are made to, gifts to the same person or group of people, for example, children, can be considered together to demonstrate a pattern of giving. And finally, coming on to reasons for the gift. If the gift is made for a particular reason, so say you've made a gift to clear a child's debts, that might suggest that it's not part of a pattern unless gifts continue to be made for general purposes. So, for example, you might be doing this planning just because you want to give your surplus income away and there's no other particular reason. So from a practical perspective, there is an argument not to label exactly what the gifts are for. Obviously, if the gift is for the same reason, so for example, payment of school fees or birthday gifts, that would clearly indicate a pattern of giving. The second condition is funded out of income, and the gift must be made out of income taking 1 year with another. So income is not defined in the legislation, but normal accounting principles are generally used, and income will be income after payment of income tax. So whilst there isn't a definition in the legislation, HMRC do have their IHT 403 form, which gives us a really good indicator of what they consider to be income and income expenditure. So, for example, a gift of capital assets such as jewellery or property will not qualify for the exemption. Common sources of income are income from employment, rents from property, pensions, interest and dividends, and all of those would qualify. HMRC will look first at the income arising in the tax year in which the gift is made, and if there's insufficient income in that tax year, you can then take account of earlier year's income, which we're going to come on to a bit more detail later. The third condition to obtain relief is that you must be able to show that after the payment of gifts, there's sufficient income to maintain your usual standard of living. Gifts will not be exempt if you have to rely on capital to meet living expenses. Now, that said, in practical terms, it's not necessary to show that the income has actually been used to meet living expenses. It is possible for capital to be used, and you don't need to carry out an audit trail as long as it possibly could have come out of your income. So in summary, there's no reconciliation for what you've paid. It's just really important that you've got enough surplus. Moving on to best practice, we advise all our clients carrying out planning with surplus income to keep clear records as they go along. So we've attached an extract on this slide of the relevant page from the inheritance tax forms that would need to be completed on death to claim gifts made as part of normal expenditure out of income exemption. And this is all the information that we would need to collate and submit to HMRC on death. We give it to our clients during lifetime and encourage them to carry out this exercise on an annual basis so that they can calculate the surplus and assess what gifts can be made. It's a really good way of keeping track of the gifts and also much more efficient than trying to go back over old records when someone dies. The slide also shows what would class as income expenditure and what we do not need to take account of, such as capital expenditure, which would include buying a car, new windows, or a roof on a house. Catriona is going to talk about the use of trusts for surplus income, and there are times that we have to report gifts to HMRC before death. And again, in those instances, this is exactly what we would be submitting for that. Accumulated surplus. So if you haven't been making use of the exemption already and you've got accumulated surplus income, it can be really effective planning to look to use that accumulated surplus. And we've been doing lots of this planning recently. HMRC's view is that income becomes capital after a period of 2 years. And so generally you can look back 2 years to see if you've got any accumulated surplus. The 2-year assumption can be rebutted either way if there's evidence that income has either been retained as income or turned into capital. So if income from earlier years is going to be relied upon, it's important to be able to show it's been accumulated as income and retains its character as income. In those circumstances, we generally prefer the payments to come from current accounts where income may have built up in the account over time. If income is retained in a form to receive income such as capital investments, it is likely to be deemed to be capital unless you can show that that was being held for a temporary purpose. The other point to just be aware of on this is it is possible to start and establish a pattern of giving with your accumulated surplus, but it's really important that you continue to make those gifts moving forwards, otherwise they would just be considered one-off gifts. So a slightly different point in relation to life insurance premiums, but one that it is really useful to be aware of. Lots of people consider taking out life insurance to cover an anticipated inheritance tax liability on their death. So, for example, you may take out a life insurance policy for the benefit of your children or a policy that's written in trust. Now, a key point to be aware of that's often missed is if you are paying the premiums of funding that life insurance, that is actually treated as a gift by you. And if you haven't got surplus income to fund the payment of those premiums, it will be reducing your available nil rate band, which is a really important point to watch out for. In addition to the fact that it will be eating into your nil rate band, the reporting of that becomes quite complicated on death, as it has to be reported on a monthly basis in the forms. So before I hand over to Catriona to talk about how to give surplus income and the various options available, I just wanted to spend a couple of minutes looking at some important practical aspects. So I've already talked about the importance of establishing a pattern of giving to qualify for the valuable exemption. We also recommend using a letter of intention to help establish that pattern and record the intention. So the letter would set out approximate calculations of what your surplus income is at the time of writing and record when the gifting is going to start. And it will also make it clear that the intention is to continue making those gifts out of your surplus income moving forwards. Having that letter in place is really valuable evidence and puts us in a much stronger position to present the matter to HMRC that a pattern has been established, even if you've only had time to make the initial gifts. A letter of intention isn't legally binding, so if your circumstances change at any point, that's no problem. You can simply stop the gifting. A different challenge arises on loss of capacity, and the starting point with that is even if you've got, for example, a lasting power of attorney or an enduring power of attorney in place, an attorney cannot make gifts on behalf of an incapacitated person under a power of attorney without court approval. Now, that can be problematic for a number of reasons. An application to court is very expensive and time-consuming. So to guard against the issue and allow gifting of surplus income to continue in the event of loss of capacity, a deed of covenant can be entered into. Now, a deed of covenant can be used to create a binding agreement to continue to make gifts out of surplus income, even if the individual cannot make the gift themselves. Careful thought needs to be given to entering into a deed of covenant and whether it's appropriate, because if one were to lose capacity, it cannot be revoked, and to the extent that there is surplus income at the time, there would be an obligation to continue to give that away. It's important to note that if there's no surplus, perhaps care fees were using up available income, then the deed is drafted to ensure that gifting would cease. Deeds of covenant can be really valuable from an inheritance tax perspective, as they allow surplus income gifting to continue and avoid that unspent income accruing and building up in an estate for inheritance tax purposes.
Thank you, Grace. As Grace has explained, for the exemption under Section 21 of the Inheritance Tax Act to apply, we have to be able to show that a gift formed part of the donor's normal expenditure, that it was made out of income, and that the gift left the donor with enough income for them to maintain their normal standard of living. Establishing the pattern of gifting is really important, but as Grace has explained, gifts don't necessarily have to be made on a monthly basis to be regular. They can effectively be annualised and still satisfy the requirements. Before we look at how gifts are made, there are some important factors to have in mind. The value of the surplus that is available to be gifted is likely to influence how it's gifted. If the annual amount of surplus is fairly modest, or the appetite to gift surplus income isn't particularly high, the strategy for how gifts are made might be different, perhaps to a case where the surplus is higher. This is particularly relevant if an exercise is being carried out with the accumulated surplus that Grace talked about from the previous couple of years. Thought should also be given to who is receiving the income. Sometimes there's a really small pool of people who are going to benefit or could potentially benefit from surplus income gifting, perhaps children and grandchildren. In other cases, whilst the intention to make gifts is clear, there might need to be more flexibility required on who takes the benefit. For example, you might want to have the option of benefiting a wider range of people, perhaps the combination of family members and friends. It might be that someone you want to benefit from gifts isn't actually in a position to receive and handle the money, either due to age or perhaps their personal circumstances. They might not be very good with money. They might be very young. They could be experiencing a relationship breakdown, and adding money into their estates at this point isn't going to be sensible. Or it could be that the amounts involved are large and would create a tax planning problem in their estate. We're effectively kicking the IHT can down the road to the next generation. So with all that in mind, we'll have a look at the gifting options that are available and that we use. The simplest option is always, in any event, going to be making an outright gift. These can be made monthly, annually, on an ad hoc basis, as long as there's a clear intention to make the gifts and a pattern of gifting is established, and Grace has covered this really thoroughly. Bare trusts provide a good middle ground. They allow for an outright gift with some protection due to the fact that there's a trustee holding the money for the recipient of the gift, effectively standing there as a bit of a barrier, if you like. Having said that, if the recipient calls for the money, it has to be given to them. It does belong to them. Third option is to make gifts on discretionary trust. This can give a really good solution when you want to make regular gifts of surplus, but you don't want the money to pass outright to individuals, or perhaps where you want flexibility over who has how much and when. The trust also gives protection for the potential beneficiaries from relationship breakdowns and for their own management, and it helps keep the value outside of their estates for inheritance tax. So it can effectively be seen as a bit of a piggy bank where the surplus income is accumulated and pooled outside of the donor's estate. Where there's quite chunky surplus being gifted, including where we're gifting income that's been accumulated, there's a really valuable opportunity to gift to multiple trusts. Since 2015, there is only one nil rate band available for a discretionary trust in a 7-year period due to the related settlement rules. If a person creates more than one trust in a 7-year period, the nil rate band is effectively shared between them. However, where we use a trust to catch surplus income, because the gift itself is exempt, and provided trusts are not created on the same day, there's no limit to the number of nil rate bands that are available for surplus income trusts. This is a really valuable allowance, because what it means is that with careful planning, we can avoid or reduce the exposure to the 10-year charge by having trusts with multiple nil rate bands. So a little bit like we were in the position pre-2015 for a normal discretionary trust. So I'm going to take you through a couple of short case studies to illustrate how this can work in practice. So our first case study is Charlotte. Charlotte was in her early 60s when we were looking at this for her, and had a senior position in an engineering business. She had received some large bonuses in the previous few years, and she was a high earner. She hadn't previously made any gifts and wanted to fund education costs for her 3 grandchildren. When we reviewed her income position, we found that she had quite a significant surplus. And due to some large bonuses a couple of years before, she had accumulated surplus of 500,000 and in a typical year, 100,000 annually. So with the 600,000, what could we do with it? Rather than make outright gifts, we set up a trust for each of the grandchildren into which she gifted £200,000. The money in those trusts was then used to fund the education costs for each of the children. And each year, she then divided her surplus, which, as I said, was usually around 100,000, between the trusts to effectively top them up. Each of those trusts is then going to have its own nil rate band because we set them up on consecutive days, and therefore they're not related settlements. Because although we're topping up, we're also spending out of them, it's unlikely that the individual trust will exceed the nil rate band of 325 on the respective 10-year anniversaries, and therefore there shouldn't be any anniversary charges, contrasting that with how the position would have looked if we just used one trust. This gifting was reported to HMRC because if the gifts didn't qualify under Section 21 as normal expenditure out of income, they would be chargeable lifetime transfers and subject to an immediate IHT charge. So this was reported on it's a form IHT 100, and HMRC then write to acknowledge that, and effectively they give a date, and if by that date you haven't had any inquiries from them, you can work on the basis that the claim has been accepted. We got past the date on this one, and therefore the claim was successful. The second case study relates to Stuart. So like Charlotte, Stuart has got significant income and surplus income. He was looking at setting up a family investment company, a FIC, and he had earmarked £10 million for this. Of this 10 million, £1 million of it was effectively funded by surplus income, and Stuart wanted to use a family trust to hold shares within his FIC structure. So we could just use one trust for the full 1 million. However, he is going to keep adding value each year with his surplus, and we've got in mind the 10-year charge. So don't be daunted, but instead what we did with this one, we actually set up 4 discretionary trusts. You'll see that the first trust only has 25,000 in it, with the others 3 holding the full nil rate band of 325 each. Rather than have 4 family trusts with shareholdings, which becomes tricky and a bit cumbersome sometimes, only one family trust 1, will hold shares in the FIC. Trusts 2, 3 and 4 made interest-free loans to Trust 1, and Trust 1 alone then subscribed for £1 million worth of shares. On the 10-year anniversary, the value of Trusts 2, 3 and 4 remain the same, as their only asset is the initial loan, non-income producing. So Trust 1 will have the benefit of the growth from the FIC shares and has got 300,000 headroom for that growth. So depending on how well the investments go, there might be some reporting in there, but we've got a full nil rate band to cover us. In the next year, we set up a further trust to receive that year's surplus, and again lent that money to Trust 1. Once we've then filled that trust up to 325,000, we could then look to set up another one, and so we go on. Now, we have to acknowledge that multiple trusts means multiple trust registrations with HMRC, but there's no ongoing reporting for trusts 2 to 5 because they only hold debt that isn't producing income. Trust 1 is only going to have to complete a tax return if a dividend was paid. So other than making sure we keep up to date with the trust registration, actually there is very little ongoing administration required in these trusts. As with Charlotte, HMRC accepted the claim that Stuart's gift to trusts were normal expenditure out of income, past the date with no inquiries. And so this was really effective planning for him. So hopefully these examples give a flavour for the flexibility that can be incorporated in surplus income planning. And I think the message is that everybody's situation is different. It isn't a one-size-fits-all approach. And what we tend to do is sit down with clients and look at what their personal circumstances are, what their objectives are, what their wider planning is, and see how this fits in as part of that planning. So we've given you a broad overview, hopefully, of surplus income planning in the time allowed. We are getting close to the time, but I can see that we have got quite a few questions coming in. So I think we'll try and cover some of those, and any that we don't get to, if you want to pop them, any others in the box, we'll try and get back to you afterwards. But just looking at the questions we've got, so here we've got an interesting question coming in relation to how the surplus income gifting exemption works for married couples, in particular, how expenses are apportioned between them. Grace, do you want to pick that one up?
Yeah, so there's lots of flexibility and judgment in how we allocate expenses. We tend to look at a fair and reasonable apportionment, and generally, if we can justify it as being fair and reasonable, HMRC are likely to be happy with that. So to give you as a general rule of thumb, if expenses are being paid from a joint account, then we would typically, as an initial starting point, look to allocate those between husband and wife on a 50-50 basis. If expenses aren't being paid from a joint account, the starting point is who is paying the expenses. That's not to say there's no wiggle room on that. So each case would need to be considered on its facts. For example, if a spouse had put the other spouse in funds to meet a liability, there might be scope to look at that. I think the other point to mention on that is if there's something unusual or controversial that we're saying is happening, we would have to just give some careful thought to how we present that to HMRC and make sure we are disclosing the full facts to them. So hopefully that helps in answering your question. But yeah, lots of flexibility on how they're allocated and presented.
Great, right. We've got a few others. We're definitely not going to get to all of these, I'm afraid. So do put your details in and we'll come back to you afterwards. We've got another question that's come up a couple of times about whether the 25% tax-free amount that can come out of a pension can be used for surplus income gifting. This is a really interesting question. So pensions and what people do with them is obviously a really big talking point after the government announced that pensions will be subject to IHT for deaths on or after 6th April 2027. And I think we're unlikely to see pensions remaining untouched in a lot of cases now. We know that clients are thinking about turning on their pensions to generate an income, which might then leave them with a surplus, and then they might want to gift that on. And the question around the 25% lump sum isn't completely straightforward, and we're not aware of any definitive guidance or commentary on the point. And it might be that if taxpayer behaviour change, HMRC practice might develop. But the IHT manual does refer to pensions as a common source of income in the same way that ISA interest is, or salaries, or other property income, for example. And that's for the normal expenditure out of income purposes. The manual also highlights that payments received on a regular basis may appear to be income, but are in fact capital in nature. And a good example of that would be where people are taking 5% withdrawals from a bond. You know, people feel like it's income, but it's actually a return of capital. Less helpfully, the manual does say that HMR's view is that income should be determined on normal accountancy principles, which Grace mentioned before. And there is therefore a school of thought that a lump sum, once you call it a lump sum and take it in one go, might be argued to be a pseudo capital distribution. And therefore, if it's taken as one payment with no regularity, query whether it is capital. I think ultimately the way I look at this is a pension is a vehicle, a savings vehicle, and you are allowed to take 25% off that, or capped at 250,000 if you didn't cap previously, without paying any income tax. And then after that, you pay income tax at your marginal rates, depending on how much you take out. You could take the whole pension out in one go and pay income tax on it. So ultimately, if you're taking out the first 25% and you're just taking that as income, surely that is income, it's a pension. And so I can't see why the argument would differ if you took it out as a larger amount. Now, remember, this only becomes an issue if someone dies within 7 years of taking the lump sum and gifting it, because if you survive 7 years, then we don't have to make a claim anyway. If you're gifting it into a trust, then you obviously have to report it during lifetime. But on the IHT 403, in the box marked pensions, we put in the amount that has been received as pension, and we will have to see whether or not HMRC would come back and say, oh, you had a particularly big amount of pension this year, but it doesn't get identified as the fact that that wasn't paid tax on, and technically it can have tax paid on it. So a bit of a long-winded way of answering the question, but I think overall we're probably okay on it, but I'd want to look at it on a case-by-case basis and look at the numbers involved and the wider structure and strategy around the gifting, to make sure that we're not falling into a one-off gift trap. I'm conscious that we are really running over now, so I'm going to draw to a close now. You will get a feedback form after the session, and if you can find the time to fill that in, it'd be really appreciated. It's really valuable for us to know how these sessions go for people. But thank you very much, Grace, for sharing your thoughts on this subject, and thank you very much all for joining us today. Thank you.